If you were arrested for domestic violence and you got a letter from the city attorney's office, maybe it looks like this with all the black that I have redacted here, then this video is for you because I'm going to be explaining what that means and exactly how to deal with it. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything that you need to know to represent yourself in a restraining order hearing. So if in addition to dealing with this arrest, the alleged victim also filed for a restraining order against you, then that is exactly what issue my course helps you with is cut, and you are planning to represent yourself in that restraining order hearing, then the course is for you because you can represent yourself in a restraining order hearing without an attorney and win. You just have to know what to do, and I teach you exactly how to do that in my course. Okay, so let's jump right in. You've got a letter from the city attorney's office. It looks pretty foreboding, and you are wondering, is this a good thing? Is this a bad thing? What is going to happen at this city attorney hearing? So let me explain that right now. Okay, so let's jump right in. You got a letter from the city attorney's office. It looks pretty foreboding. This one is from the city attorney of Los Angeles and looks pretty scary, right? And you are probably wondering, what is a city attorney hearing? What does that mean? What does it mean for my case? Now, you might have gotten one of these letters either before your first court date, or you might have actually shown up to court. And this happens a lot in LA, where you will show up to CCB 210 West Temple Street downtown, Department 30 or 40, and they tell you nothing has been filed yet. It has been referred to the city attorney. Nobody explains anything, especially if you don't have an attorney at that point. So you're wondering, like, what does that mean? And then you get this letter in the mail. Okay. So here is how it works, and I'm going to be talking about this in the context of domestic violence. So let's say that you were arrested for PC 273.5A as a felony. If you're not sure if it was a felony, if your bail was set at $50,000, you probably paid $4,000 or $5,000 to a bail bondsman. In that case, then that means it was probably a felony, especially if it was your first time getting arrested. Okay, so the fact that you got this letter then is good news because the city attorney only prosecutes misdemeanors. So basically what likely happened is that initially all felonies go to the district attorney's office. And that is the prosecutor's office that can handle all crimes, and they handle the most serious crimes. But then there are also the city attorney's offices, and they only handle misdemeanors. So what happens if you get arrested? It goes to the DA's office first, the more serious prosecutor, right? And they look at the case, and sometimes they are going to decide that they decline to prosecute it. Maybe your attorney contacted them and explained all the good things about you, explain your side of the story. Maybe there's a letter from the alleged victim. All those things can make it more likely that the DA will decide, you know what, I'm just going to throw this thing out altogether. Another option, though, is that the DA could also decide, well, we don't want to prosecute this, but we'll give it to the city attorney, like the baby prosecutors, and see if they are interested in prosecuting this thing as a misdemeanor, right? And so then the city attorney has a few options. They can just decline it. They can say, we don't want this one either. Maybe the packet from the attorney is really good and they think, you know what, we will just give this guy another chance. If we see him with another case in the future, maybe we'll prosecute, but it looks like he's going to therapy, he's going to domestic violence classes, he has a bunch of character letters. This is his first arrest ever in his whole life, and he's doing a lot of things, so we're just going to drop this one for now as long as he doesn't get in any more trouble. That would be great. They can also decide, yeah, we want to prosecute this, and they can file charges and send a letter out to you saying a court date that you have to appear and say that charges have been filed against you. Oftentimes they will send it to the wrong address. So if I have a client that is in this situation, we're always calling to find out, have charges been filed, maybe annoying them. But if you don't do that, then you might end up getting a warrant, and we do not want that to happen. And then the third option is that you get a letter from the city attorney's office. Now, when you get one of these, the alleged victim is getting one too. And that means that the city attorney's office wants some more information to decide whether or not this is a case that they should file. They want to talk to the alleged victim and they want to talk to you. Now, this is an informal proceeding. It is either in their office or actually lately since COVID, and I don't know if they're going to resume the in-office ones, it has just been over the phone. And basically this is your chance, whether or not the victim is on your side, to put forth your side of the story and convince them not to prosecute. So I will just tell you, and this is not even a humble brag, it's just a brag. My success rate at getting them dropped if we go to a city attorney hearing is 100%. However, I have been hired by numerous people who had a city attorney hearing. They did it themselves, and the DA decided that they were going to prosecute, filed charges, and then they hired me at that point. It would have been better for them, obviously, to hire me before the city attorney hearing. So if you do get one of these letters, I mean, this is not something to take lightly. So if you get one of these letters, it is good news, especially if initially you were arrested for a felony. The worst thing that these guys can do is give you a misdemeanor, but it's still something to take really seriously. I mean, I focus my practice right now with domestic violence, especially if it is your first offense. It is really important to be proactive, to do everything that you can to get things dropped early. Because if you wait and the charge has already been filed, now instead of them assigning you a hearing officer to just listen to everybody who can easily just drop the case, who drops probably at least half of the cases that they come across, instead you get assigned a prosecutor whose job it is to get a conviction. And that is not what you want. So be proactive, act early, take this seriously, and make sure, especially if it's your first arrest, and especially if you didn't do anything wrong, that you don't end up with a criminal record because of this. I hope you found this video helpful. If you did get one of these letters, anywhere in the state of California, I practice from Eureka all the way to San Diego and way into the desert. Feel free to give me a call. You can find my number down below. You can also book a consultation with me directly there. And if you were served with a restraining order, then make sure that you get your free first class via the link down below. If you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.